5 seconds to go. Start. Thus, the plain reading of the decree referred to above indicates that the plaintiff was directed to deposit the balance sale consideration in the court within a period of 20 days, and the defendants at the same time were directed to execute the sale deeds in favor of the plaintiff. Before the plaintiff could deposit the balance sale consideration as directed by the trial court within the stipulated time period of 20 days, the defendants went in appeal before the district court. The appeals were preferred on 26 August 1994. The first appellate court allowed the appeals, while judgment and order dated 16 August 1994. Thus, the judgment and decree passed by the trial court granting specific performance came to be set aside. In such circumstances referred to above, the plaintiff went to the High Court and filed regular second appeals. All the second appeals came to be allowed, while judgment and order dated 3rd May 2018 and the judgment and order passed by the appellate court came to be set aside, and the original decree passed by the trial court granting specific performance came to be restored. Against the judgment and order passed by the High Court in second appeals, the defendants came to this court seeking leave to appeal. While the SLPs filed by the defendants were pending before this court, the original plaintiff decree holder preferred execution petition on 4th September 2018. The plaintiffs prayed for permission before the executing court to deposit the balance sale consideration, and the same was granted by the executing court, while order dated 7 September 2018. On the very same day, the plaintiff deposited the balance sale consideration. On 18th January 2019, this court dismissed all the SLPs filed by the defendants herein, thereby affirming the judgment and order passed by the High Court in second appeals filed by the plaintiff. On 4th April 2019, the defendants' judgment debtors filed an application under Section 28 of the Act to rescind the contract. The executing court, wide order dated 16 August 2019, rejected the application filed by the defendants under Section 28 of the Act referred to above. What is important to note is that in 2019, the sale deeds were executed by the defendants in favor of the plaintiffs, while the impugned judgment and order dated 23rd September 2022, the challenge to the orders passed by the executing court dated 7 September 2018 and 16 August 2019 respectively also failed. On 29th November 2022, the warrants of possession were issued for the purpose of execution of the decree. On 7 December 2022, the execution petitions came to be dismissed as withdrawn, as possession of the suit lands was handed over to the plaintiffs. On 15 December 2022, this court, while issuing notice in the present SLPs, stayed the further proceedings of the execution petitions. It appears that it was not brought to the notice of this court that the execution petition had already been disposed of, and the possession of the suit lands had also been handed over to the plaintiffs. In view of the aforesaid, two questions of law fall for our consideration. First, the effect of merger of the trial court's decree with that of the decree passed by High Court in second appeals. Secondly, whether the defendants' judgment debtors could have prayed for rescission of contract on the ground that the plaintiffs' decree holders had failed to deposit the balance sale consideration within the stipulated time period of 20 days as prescribed in the original decree. Section 28 of the Act reads as follows: rescission in certain circumstances of contracts for the sale or lease of immovable property, the specific performance of which has been decreed, where in any suit a decree for specific performance of a contract for the sale or lease of immovable property has been made and the purchaser or lessee does not, within the period allowed by the decree or such further period as the court may allow, pay the purchase money or other sum which the court has ordered him to pay, the vendor or lessor may apply in the same suit in which the decree is made to have the contract rescinded, and on such application the court may by order rescind the contract either so far as regards the party in default or altogether as the justice of the case may require. Where a contract is rescinded under subsection 1, the court shall direct the purchaser or lessee, if he has obtained possession of the property under the contract, to restore such possession to the vendor or lessor, and may direct payment to the vendor or lessor of all the rents and profits which have accrued in respect of the property from the date on which possession was so obtained by the purchaser or lessee until restoration of possession to the vendor or lessor, and if the justice of the case so requires, the refund of any sum paid by the vendee or lessee as earnest money or deposit in connection with the contract. If the purchaser or lessee pays the purchase money or other sum which he is ordered to pay under the decree within the period referred to in subsection 1, the court may, on application made in the same suit, award the purchaser or lessee such further relief as he may be entitled to, including in appropriate cases all or any of the following reliefs, namely the execution of a proper conveyance or lease by the vendor or lessor, the delivery of possession or partition and separate possession of the property on the execution of such conveyance or lease. No separate suit in respect of any relief which may be claimed under this section shall lie at the instance of a vendor, purchaser, lessor or lessee as the case may be. The course of any proceedings under this section shall be in the discretion of the court. The present section corresponds to section 35C of the Specific Relief Act 1877, hereinafter referred to as the repealed act, under which it was open to the vendor or lessor in the circumstances mentioned in that section to bring a separate suit for rescission, but this section goes further and gives to the vendor or lessor the right to seek rescission in the same suit when, after the suit for specific performance is decreed, the plaintiff fails to pay the purchase money within the period fixed. The present section therefore seeks to provide complete relief to both the parties in terms of a decree for specific performance in the same suit without requiring one of the parties to initiate separate proceedings. The object is to avoid multiplicity of suits. Likewise, under the present provision, where the purchaser or lessee has paid the money, he is entitled in the suit for specific performance to the reliefs as indicated in subsection 3, like partition, possession, etc. Stop.